All right, welcome to This Explainer. Today, we're unpacking a massive legal collision that actually went all the way up to the Constitutional Court of South Africa. We're looking at a huge clash between a corporate betting giant and independent bookmakers over, honestly, a surprisingly complex question. Who actually owns the numbers that drive a betting market? Let's dive right in.
Now, I want you to picture this scenario. You run a business, right? And you spend just massive amounts of time, energy, and, well, money crunching numbers to generate incredibly valuable data. Then your direct rival just waits. They wait for you to publish your answers, and then they literally use them to run their own operation against you, completely for free. It's basically the corporate equivalent of copying someone's homework. So you have to ask yourself, is that just a savvy business move, or is it straight up theft? Well, that exact dilemma is what ignited the legal turf war we're looking at today.
To really grasp the stakes here, we first need to understand the sheer scale of the operation. The applicant in this case is Phumelela Gaming and Leisure Limited. And listen, they are not some small-time operation. They run a highly sophisticated national totalisator system. We're talking about roughly 2,600 betting terminals spread across 220 branches, and all of it is linked to this massive central computer. So they've built a machine with incredible reach and, as you can imagine, serious earning potential. So the friction here really stems from two completely different business models. Think of Phumelela's totalizer system kind of like a giant potluck. The operator actually takes very little risk here. All the money wagered is just pooled together. They take their cut for admin and taxes, of course, and then the rest is split equally among the winners as what they call dividends. Now, on the flip side, we have traditional bookmakers. They are the ones taking on the risk. They have to calculate the likelihood of an event and actually fix the odds before the race even starts.
But here's the thing. The spark that really lit the powder keg was something called an open bet. According to the National Gambling Act, an open bet is a wager where no fixed odds are agreed upon when the bet is actually placed. Instead, the bookmaker just waits. They wait for the race to finish, wait for Phumelela to do all that heavy lifting to calculate and publish those totalizer dividends, and then they use those exact same numbers to pay out their own customers.
You can probably guess exactly how Phumelela felt about this, right? I mean, they naturally broadcast their dividends on TV, on the radio, in the press, so their winners actually know what they've made. But they essentially looked at the bookmakers and said, hey, do your own math. Phumelela argued that the bookmakers were basically free-riding. They were piggybacking on this super expensive system and all that business goodwill without taking on any of the actual operational costs. So legally speaking, Phumelela called this a delict, specifically unlawful competition.
And man, this disagreement sparked an absolute legal roller coaster. Phumelela actually struck first, taking the case to the High Court in Pretoria. And guess what? They won. The court ordered the bookmakers to stop using the dividends, but the bookmakers fought back. They took the case to the Supreme Court of Appeal, and in a pretty dramatic reversal, the SCA ruled that the bookmakers' actions were not unlawful. Unwilling to back down, Phumelela took their fight to the absolute highest court in the land, the Constitutional Court of South Africa. Now, to actually get the Constitutional Court's attention, Phumelela had to elevate this. They had to make it a constitutional issue. Their strategy? They invoked Section 39(2) of the Constitution. Basically, this section acts as a sort of guiding light for judges. It obligates courts to promote the spirit of the Bill of Rights whenever they're developing common law. Phumelela argued that the lower court just completely missed this and that they failed to view their hard-earned data and goodwill through a protective constitutional lens.
So this whole thing set the stage for a massive constitutional balancing act. In one corner, you have Phumelela leaning hard on Section 25, which is the property clause. They argued, look, our calculated dividends are our property, and letting rivals just use them is an arbitrary deprivation of that property. But you know, the Bill of Rights isn't exactly a one-way street. In the opposite corner is Section 22, freedom of trade. That section guarantees citizens the right to compete freely. So suddenly, the court is forced to weigh strict property rights against the principles of a free market. To break this tie, the court leaned on a really foundational concept in the law of delict called boni mores. You can kind of think of it as society's legal vibe check. It's essentially the standard of what the community considers reasonable, honest, and fair. But keep in mind, in modern South Africa, this isn't just based on vague feelings. It's deeply tied to the objective values laid out in the Constitution. So for the bookmakers' competition to actually be deemed unlawful, it had to deeply offend the community's sense of fairness. Okay, so how does a court actually measure fairness in the real world? Well, Chief Justice Longa outlined a very specific checklist to test for wrongfulness. First, they look at the honesty of the conduct itself. Then they look at the accepted morals within that specific trade sector. They also look at existing legislation, what laws are already on the books. And crucially, they heavily weigh the importance of a free market. Because let's be real, the right to free trade absolutely demands competition. And by its very nature, competition is always going to pose at least some threat to a rival business. And when digging into those morals of the trade to see what the community actually accepts, the court found a literal smoking gun in the legislation itself. It turns out the National Gambling Act of 2004, along with various provincial laws going back literally decades, explicitly define and permit bookmakers to take these open bets using totalisator dividends. So the law actually sanctions the exact practice that Phumelela was trying so hard to shut down.
As you can imagine, this led to a pretty devastating realization for Phumelela's case. As the Supreme Court of Appeal reasoned earlier, and the Constitutional Court totally agreed here, if a practice has been officially sanctioned by legislation for a really long time, and it's just deeply embedded in the industry, well, it could never really be said to be unfair or dishonest. Society's moral compass, those bony mores we talked about, isn't going to suddenly condemn a practice that the law has openly permitted for years.
Which brings us to the final, really looming question of this whole saga. If the competition isn't technically wrongful, according to the gambling laws, well, what about the Constitution? Did the lower court's ruling actually result in an arbitrary deprivation of Phumelela's intellectual property? In other words, did letting the bookmakers use this data violate Section 25 of the Bill of Rights?
The Constitutional Court delivered the final verdict, and the answer was a resounding no. Phumelela's appeal was officially dismissed. The court ruled that yes, while business goodwill is absolutely a valuable asset, the Constitutional Property Clause is not some absolute magical shield that immunizes a business from all competition. Because the bookmakers were engaging in a practice that was already legislatively recognized, it just wasn't wrongful, and therefore it wasn't an arbitrary deprivation of property. Ultimately, the free market won the day. As we wrap things up, I want you to consider this. This case is about so much more than just horse racing. It poses a fundamental question for literally any data-driven industry operating today. Where exactly is the boundary? At what point does protecting your hard-earned business data cross the line into actually stifling a free and open competitive market? It's a remarkably fine line. And as we saw today, sometimes the law decides that competition just has to prevail. Thank you so much for joining me on this explainer, and keep questioning the data around you.